Okay, we're going to go ahead and get started. Hello, everyone. My name is Garrett Droege, and I serve as Executive Director of TechAssure. I'd like to welcome everyone to today's webinar, Drafting and Negotiating Tech Contracts. Today's presenter is one of TechAssure's favorite speakers with whom we've worked with several times over the years. I think everyone will get a tremendous amount of value out of today's session. Before we begin, I want to briefly explain TechAssure and our mission to those guests that may not be as familiar. TechAssure is a global not-for-profit trade association comprised of the leading insurance brokers that specialize in technology-related risks. Since 2000, our mission's been to support our members and their clients by providing access to information and education, like today's webinar, as well as by offering tools and resources that members can use to better serve their clients in the innovation ecosystem. More information about TechAssure and our members can be found on our website, techassure.org. Today's speaker is David Tollen. He's an attorney and the founder of Tech Contracts Academy, which provides training on drafting and negotiating IT agreements. Their website, techcontracts.com, is a tremendous and free resource you should all bookmark immediately. He's also the author of the American Bar Association's best-selling book, The Tech Contracts Handbook. And finally, he's the founder of Sycamore Legal PC, a boutique law firm in San Francisco with clients ranging from Silicon Valley startups to the Fortune 100. We will be using the Q&A chat feature on the control panel to answer any questions. We'll do this periodically through the webinar today. And we are recording today's webinar, and you'll receive a copy of the materials and the recording after the event. With that said, I'd like to turn things over to today's presenter, David.
Thank you very much, Garrett, and good morning, everyone. I'm very happy to be here. Really appreciate the work that TechAssure does and the chance to speak to all of you. I want to make sure my first slide is up. Garrett, are we good? Is the system in place?
We are good to go.
Okay, fantastic. So everyone, what we're going to talk about today is drafting and negotiating technology contracts. And by that, I mean contracts surrounding software and cloud computing. So it might be on-premise software, it might be cloud computing agreements, software as a service, and other, you might call it, off-premise software. And as well, we're going to talk about contracts that support those deals, technology services agreements. And really what we're going to do is talk about some of the most important and most often misunderstood clauses that come up in those agreements. We're going to take this from the point of view of the vendor of technology to a significant extent, but not solely from the vendor's point of view. And that's because, my understanding is a lot of you are technology vendors, but if you're a seller of technology, you are almost certainly also a buyer of technology. In some of your relationships, you're licensing technology from your vendors in order to run your systems or to provide that technology as a piece of yours to your own customers. So we're really going to look at things both from the vendor point of view and the buyer point of view. And if you are solely operating as a vendor, I hope this talk will also give you some perspective on your buyer's point of view, your customer's point of view, particularly the smarter customers. A lot of times the less sophisticated customers just sign whatever they're given, but then you don't need a lot of training. This is for those customers that push back a little bit more. Okay, so in terms of what we're going to discuss today, there's an outline on the screen, and we've got 7 topics: data security and the GDPR, data breach indemnity and its problems, IP indemnity and its exceptions, secondary IP issues, by which I mean feedback rights and trademark rights, some sort of surprising stuff that goes on that can be traps for the unwary. 5th, we're going to talk about software as a service escrows and step-in rights, which is a related concept to escrows. 6th, limitation of liability and its exceptions, a seemingly simple clause that is often done wrong. And then I have a kind of grab bag of common errors that I'm gonna hit one by one very quickly at the end as topic number 7. Throughout, I'm eager to take your questions. At the same time, I have a very packed agenda and only an hour and 15 minutes to to teach it all to you. So we're sort of going to take it by play it by ear, and we'll probably take some questions during the program and other questions at the end. And I have reserved some time at the end in case questions are sort of backed up unanswered. So please don't hesitate to ask questions through the typed webinar question system, and Garrett will feed them to me at the appropriate times. So that's our outline. Before we dive into it and talk about the actual substance, I just wanted to make you aware of some additional resources that are available to you after this talk. Now, number one, and this is, this part is the shameless free plug part, is of course our company is Tech Contracts Academy. And we teach how to draft and negotiate software agreements, cloud computing agreements, tech services agreements. And that teaching involves live training, in-person training, where I come to company offices and train the staff, and we train both lawyers and contract managers, non-attorney contract drafters, as well as webinars like this one, except you have to pay for those, and we will eventually be introducing e-learning. So shameless free plug for Tech Contracts Academy, and that's our website. Also, as Garrett mentioned, I'm the author of the Tech Contracts Handbook. My grandmother feels it's the best book ever written, and so recommends it highly. It is an easy, simple, comprehensive guide to how to do these agreements, published by the American Bar Association, and you can buy that on Amazon or whatever other book retailer you go to. And then the techcontracts.com website, which is the site for Tech Contracts Academy, is also a site for free resources. And I want to particularly direct your attention there. A lot of the concepts we're going to talk about today are a little too big and a little too complex to fully grasp and finish with on a short webinar. But a lot of the guidance you need comes in things like sample contracts. And techcontracts.com has all of that for free. It has every single clause in the handbook online, so you can just copy and paste them instead of laboriously typing them in from your ebook or hard copy. And it also has free contract forms in Microsoft Word that you can download, as well as articles. So please don't miss the website and the chance to sort of flesh out some of the things you learned today with the form language that's there. And then final resource, another shameless free plug, is Sycamore Legal, and that's our law firm. And we do deals of the exact type that we're talking about here, and I also do expert witness work through Sycamore Legal. So those are all resources available to you after this talk. Okay, so that's the resources, and you've got our agenda. Let's dive into our topic. So I'm going to start out with data security and the GDPR. Data security is always high on the lists of topics that I cover when I talk about technology contracts, particularly in the age of cloud computing. But it's gotten even higher on the list lately thanks to the GDPR. The GDPR is the European Union's new statute that goes into effect tomorrow, and it's the General Data Protection Regulation. My guess is in our audience we have a combination of people who are extremely familiar with the GDPR and utterly sick of it, ranging all the way to people who haven't heard of the GDPR and everything in the middle. So with apologies to everyone at each far end, I'm gonna give a little brief explanation of what the GDPR is and how it affects your data security needs in your contracts, and then talk a little bit about data security in general. But so apologies for those who already know what the GDPR is. I'll just explain. It's a new statute it's a new law put in place by the European Union that impacts all of its member countries, and it has a series of requirements for doing data protection right, for protecting private information of European citizens. Now, your first reaction might be, we don't really do European business, we don't care. The Europeans have done something kind of unusual. They have extended the reach of this law very far into the operations of almost everyone else in the world, to the point where it's actually close to impossible to say, we don't care. It's close to impossible to ignore the GDPR. That's because the law covers just about any operations that target or could target or sell to European consumers. So you might operate a software as a service company and market very specifically to companies in Minnesota or in North America generally, and think that the European Union doesn't impact you. But if you have some European customers and as a result have some European data, it's very likely that you are subject to the GDPR. That in other words, if you didn't follow their rules, they would consider you in violation. And if you make any conscious efforts whatsoever to reach out to European customers, you're in the GDPR. You're subject to it. If you sell into the European Union, if you sell in a European currency, if you have an EU domain suffix, if you ship to the European Union, one way or another, if you're operating online or if you're operating any kind of reasonably broad sales operation, I strongly recommend that you look into get some information on whether the GDPR covers you. My guess is it does to some extent. Now you might still say, I don't care because we don't actually operate in the European Union, and sales there are incidental. But there's extremely large fines if you are covered by the GDPR and fail to comply with its terms, and that's really the risk. You find a European, government agency coming after you, after your sales that are in Europe, which they can get their hands on, or who knows what other enforcement mechanisms they might employ in order to go after an American company. And of course, if you're outside of the United States, or if you're in the European Union itself, then you're automatically in their snare. So whether you're fully operating in Europe, or you're an American or Australian or Indian company, or some other company outside of the European Union, it's a good chance that you can't avoid this new law, and the cost of complying with it will probably be much less than the cost of trying to beat it. So, and complying with it is not that hard. There's really 3 steps to it. And so, this is a course on contracts. And so we're not going to spend a ton of time on the other elements of compliance, but you need to know what they are. And it's really the middle one that's on contracts. So there's 3 steps involved in making yourself GDPR compliant. At least it can be organized into 3 steps. And a lot of what I'm doing in this talk is trying to boil down a very large and complex and confusing topic into a few simple steps. So this is the beginning of that. So step number 1, you need a compliant privacy policy. You need privacy statements to anybody who might be receiving anybody whose information you're receiving, who's covered by the GDPR, European consumers, European individuals, that is compliant with the requirements of the GDPR. 2, you need compliant contracts, particularly the contract. There's something called a data processing addendum between 2 parties operating with European data, and that is the controller and the processor. The controller is the term for the company that collects the data and is in control of it. So say you're a SaaS company and you collect a little bit of data from European consumers or from your customers who have European users. You're the controller. You're the one collecting it. And then the processor is your vendor who might be providing web support for you, or they're hosting your system. They're Amazon Web Services, something along those lines. And so between those 2 entities, there's a requirement of a GDPR compliant contract, and it's generally called a data processing addendum. We're going to talk about that. And then 3, the larger topic is compliant conduct. There's things you got to do internally about how you handle data and how you respond to requests to do things like delete data that make you GDPR compliant. So these are the 3 steps. I want to say a little side note about GDPR compliance before we get into these 3 steps. It's actually not a very safe thing, even if you think you've executed on these 3 steps, to say that you're GDPR compliant, because no one's 100% sure what GDPR compliant means. It's a brand new law. As I said, it goes into effect tomorrow. The European government agencies haven't figured out how they're going to enforce it. It has a lot of kind of vague language that no one's sure, exactly what it's going to mean. It uses terms like occasional processing. What does occasional mean? So I wouldn't be putting up a statement on my website if I were you saying we're GDPR compliant. Safer to say we are addressing the GDPR and we have GDPR focused contracts, and privacy policies, things like that, rather than making a claim that could possibly get you in trouble. All right, let's talk about the 3 steps for GDPR compliant as part of our larger conversation about data security. So first step, GDPR privacy policies. Now, just what you're looking at here is kind of an ugly slide. I do not believe in doing talks where the audience spends a lot of time reading slides. So I'm not asking you to read this long, ugly slide right now. The reason I'm providing it to you is because it's a really good issue spotter for a GDPR privacy policy. This is my list of the requirements of the statute for what your privacy policy should say to make you GDPR compliant, at least to make the privacy policy GDPR compliant. So instead of reading this now, save it is my recommendation. Speaking more broadly than this list, to have a GDPR compliant privacy policy, there are 3 sort of broad requirements, and that is that you have a description of what you do with consumers' data that is concise, transparent, intelligible, and easily accessible. That means an extremely long, technically complex privacy policy isn't going to be considered compliant. You got to explain things in terms that regular people can understand. Now, it can be in English. You don't have to have a privacy policy translated into every language. If you're doing business in English, it's fine. But it's got to be concise, transparent, intelligible, and easily accessible. And a lot of companies have done sort of layered privacy policies. They have a really short, simple one, and then they have links to where you can go to get more detail. It's got to be written in clear and plain language, particularly if addressed to a child. So again, that's more about the sort of plain language and the idea that some companies do layers. If you are selling products and services that go to children, the bar is even higher for you to make your privacy concise and clear. And then finally, the privacy policy has to be free. There can't be, any requirement of signing up or paying any money or anything like that to get to see it. So those are general requirements for the privacy policy. And then, as I said, this slide has a list of the more specific requirements, things like disclosing your own identity and contact details if you're the controller. And if you have a data protection officer, which we'll get to, disclosing how to reach that person. The purpose and legal basis, the reason you have a right to control that data, to hold that data, the type of data you collected. A lot of this is probably consistent with privacy policies that you already have, but it goes beyond what's become a sort of typical worldwide privacy policy. There's new requirements. It's going to be the typical privacy policy because the whole world is going to be forced to comply with European standards, but it's worth having a look and save this slide as your checklist as you prepare a privacy policy. This should guide you through the things that you need to think through. And let me really emphasize that. I think there's an enormous value in checklists and issue spotters in legal topics. You can't always have the answer at your fingertips, but if you know that there's an issue, you can go find the answer. And this lists the issues to think about for a privacy policy. So that's the privacy policy. The contract. A GDPR compliant company has contracts between the controller, the company that collected the data and controls the data, and its processors, its vendors who also have access to the data. So your tech support people, your cloud host, whoever it might be who has access to your data. You need a DPA. It's a data processing addendum. And I call it an addendum. It's called an addendum because usually it's not the only part of your contract. Let's say, there's a contract between your company, which provides, let's say, software as a service, and your web host. The data processing addendum is an attachment to your broader contract that says things like, what you have to pay for the services and when it's going to be on and service level agreements and all that. The data processing addendum has some general disclosures that need to be there. The contract needs to state the subject matter and the duration of the processing, the nature and purpose of the processing, the type of personal data and the categories of people whose data you'll be collecting, and then the obligations and rights of the controller. Now, in the past, this has really been looked at as a contract that's really important for the controller, the company that collects the data, to go get from its vendors. Now, under the GDPR, I think it's just important for the vendors to get one of these contracts. If you're, say, providing technology services to companies and you don't think that you're ever a controller of data, it's their data, you still might probably do want a data processing addendum because, first of all, you're subject to the GDPR independently, even if you're the processor, even if you're not the one who controls the data. But second of all, you want to confirm in that contract that you're not the controller, that the higher obligations of the controller are on them, not you. So you want one of these contracts. And then this is another slide, this new slide, that is not something I want you to read now, but I recommend that you save as a checklist for what kind of things should be in that data processing addendum. What you want if you're the controller of this data in your contracts with your vendors, or what you want as the processor with your customers. And it's terms like, it's restrictions on the processor. You only act with the written instructions of the controller. The vendor's not going to run off and do crazy stuff with the data. It's only going to do what the controller asks. Have NDAs or other security agreements with staff who can access the data. Take appropriate security measures, etc. All these bullets here. So again, save this as your issue spotter for those data protection addendums. You've probably been seeing these contracts. The bigger vendors are, that might be supporting you, MailChimp, Amazon Web Services, etc. They're all sending out these addenda, and you don't have much choice. You got to sign it, but at least you can understand what you're signing. But you might need to prepare some of your own addenda for your own partners. All right, so that's the contract terms. And then again, we're not going to spend a ton of time on this, but I want to just make you clear on GDPR compliant conduct. It's not enough, despite some belief out there to the contrary, to get your privacy policy up to specs and to get your data processing addendums in place. You actually have to behave in a way that's compliant with the GDPR. Now, that is a whole huge other course. That course could be longer than this course. And so we don't have a time to go through it in detail. But again, I've given you an issue spotting slide. A principal thing you want to do is some data mapping, is figure out, it sounds like a complicated, IT technical thing to do, but it isn't. Figure out where in your organization data goes. Who gets their hands on private data? What vendors could have access to it? And you might even go beyond that, and in some cases there's a requirement of doing a formal data protection impact assessment where you're a very steady and regular processor of data. This is something that it's a little hard to say when that's required, because this is one of those requirements I mentioned of the GDPR that no one knows how, who's impacted by it. That it hasn't really been figured out. But anyway, you want to make sure that you have things like a legal basis for collecting the data. You've got a contract with the data subjects, the customers, that requires that they give you some data. Or you've given some kind of an opt-in system where you say, we need this data from you, and you can opt into providing it, and you can choose not to. Along those lines, you've probably been bombarded by cookies notices lately on websites you go to. It's kind of about the same thing. The cookies collect data, and so they want to warn you, if you use this website, you're going to be giving us data about yourself through cookies. And so that's a way to have people kind of opt in, and it's another requirement under the GDPR. You want to think about doing things like putting cookies notices on your website, pop-ups saying, if you continue to use our website, we're going to be collecting data from you. Now, again, I imagine there's some people feeling really nervous out there. We can't. This isn't the course on all these compliance items. Again, I'm giving you a checklist on it. There's a lot to think about and a lot to do. But this checklist, I hope, will guide you through it. Thorough record keeping about the personal data. You keep records of where you do it. In some cases where you have more than occasional European data collection, you even have to have a representative in the European Union, a subsidiary there, or hire some representative to be your EU representative about data claims. If you're only occasionally processing data, and you don't collect the most sensitive data like sexual orientation, health records, ethnic records, you probably don't need that. But this is another one of those frustratingly vague things that I can't really tell you because nobody knows what occasional means. But that's the language from the statute. Anyway, this is your checklist. Have a look at these items as you think about GDPR compliance, and think about whether you want to hire an attorney to do maybe a brief, low-cost sort of GDPR review of your company and figure out whether you're compliant, or rather figure out whether you're close to compliant, which, since no one knows exactly what compliance is, which, again, a shameless free plug, our firm does that. But lots and lots of other firms do too, and it's not too hard to find a firm doing this kind of work because the GDPR has had such an impact. All right, so that's the GDPR element of data security. But data security isn't all about the GDPR, and we can't forget that there's more to it. The data security clause is a part of most information technology contracts. And you might have a DPA, a data protection addendum, that addresses the specific requirements of the GDPR. But a smart customer is going to want a lot of other very specific data security terms. And I want to talk about that relatively briefly. I divide data security clauses into two topics: data management and literal data security. Data management is the part of the clause that talks about things like access, use, and legal restrictions. It says the reason that the vendor gets to access the customer's data. And it does things like promises that the vendor will comply with laws or with privacy policies. It's kind of like a non-disclosure agreement, but not quite. The thing I want to mostly make sure you understand that's often misunderstood about data security clauses is the role of e-discovery. The reason you, as the customer, might want to have really strong language on data management, and why you as the vendor might be facing that from some of your more sophisticated customers. Data security clauses help protect the customer against e-discovery problems. If you're in litigation, and the other side has the right to discover, to get copies of information that's relevant to the litigation. Nowadays, most of that is in electronic form. If your vendor has that information, the other party can subpoena the vendor to get it. And that's really distressing for most parties in litigation. They want to be the ones providing that information. Also, if your vendor has that information and they delete it, like as part of some kind of regular, data cleanup process, after the time the case was filed or the case even became possible, that's actually an e-discovery violation. You're not allowed to delete any information that could be relevant to the case. You tend to have, so that's why data security clauses have terms that restrict the vendor from deleting any information in e-discovery, and even terms that say, you'll give us, the customer, all the copies you have of our data at such time as we request through a reasonable mechanism. It's a really good idea to get that if you're on the customer side, because then you can keep the other party in litigation from going after your vendors, and instead say, to the court, we've got all the same data as our vendor, so they should come after us. We should be the ones to provide the data. And you want that because you want your lawyers deciding what to provide to the other party, not your vendor's lawyers. So that's the data management side of it. Data security is a little easier to sort of grasp. The basic elements of a data security clause are listed there. I just want to mention that one of the things that's really important from the customer's point of view is those audits and testing. SOC 1, SSAE 16, SOC 2. If you're on the customer side, you're often not in a very good position to really assess the data security of your vendor. It's too complex. That's why the audit is one of the most valuable clauses. That's where the vendor promises to have a third-party independent auditor come and test them and give them a report card on how they're doing on managing the data. That's really valuable to you. So the audit sort of shines out, in my view, as one of the central clauses of the data security terms. So in terms of putting together data security clauses, as I mentioned, there's free language at techcontracts.com, and I recommend that you go and particularly if you're in the customer position, download the long clause we've got there and look at it as sort of your checklist for everything you want to include in that kind of agreement. This slide also can provide you with a mini checklist. So that's the data security clause, really vital in the age of cloud computing. All right, before we move on, Garrett, do we have any questions? I think we have time for one, if we have one, about the GDPR or data security clauses more generally.
No questions right now.
Okay, great. Okay, well, let's move on. All right, so things get a little simpler from here because we're no longer dealing with sort of the intrusion of a new European statute in how we do contracts. Let's talk about data breach indemnities. So this is a kind of add-on conversation to our conversation about data security, but it's focusing on a particular clause. So you're probably familiar with indemnities. An indemnity is a clause that says one party is going to accept the burden of defending a lawsuit against the other. And the typical example is the IP indemnity, where the vendor says if somebody sues you, customer, for patent infringement or copyright infringement for just plain using our technology, we're going to take on the burden of that lawsuit. We're going to defend you, and we're going to pay any judgments, and we're going to pay any settlements. Data breach indemnity is, of course, that same thing, but the claim is about data breaches. The claim is about the loss of that private data, all the more dangerous and scary now thanks to the GDPR. So data breach indemnities are a lot harder to get done than IP indemnities. And one of the things I want to leave you with is an understanding of why. Whether you're going to be able to get them done regularly or not, I want you to understand what the problem is. So the problem is, let's look at let's look first at just the typical situation of the vendor as the indemnitor. The vendor's providing the indemnity. The data breach indemnity just basically says that if there's a claim against the customer, the vendor is going to come forward and defend it. Now, it makes a lot of sense with an IP claim because the whole point of the claim is it's about the vendor's technology. It makes sense to allocate that burden. But with data breach, it's a lot more complicated. With data breach, it's possible from the vendor's point of view that even though, let's say this is a cloud vendor and it's holding most of the customer's data, the vendor could be not responsible for the breach. In fact, the breach could result from the customer's wrongdoing. The customer could have done a bad job maintaining passwords to the vendor's system, or the customer's own systems might be vulnerable and hackers got in through the customer's system into the vendor's system and caused the breach. So from a vendor's point of view, they're much more hesitant to grant a data breach indemnity than they are to grant an IP indemnity. And if you're finding, you're on the customer side and you're trying to get them done, that's why. Or if you're on the vendor side and management is saying, no, we won't do that, again, that's why. It's really hard to craft an indemnity that works. So you can try and say things like the indemnitor is the party at fault. If the breach was the fault of the vendor, then the vendor is the indemnitor and will defend the case. And that is what a lot of these contracts say. And you might sign contracts that say that, but I want you to be aware of the problem with that. The problem is, at the beginning of the case, when that obligation to defend starts, the vendor might not agree that it's at fault. This is very different from saying the vendor will defend IP cases. You know, whether the case is good or not, whether the vendor was at fault or not, it's a case about the vendor's product, so the vendor is going to defend it. This fault qualification really weakens the indemnity. It's much better to say something like the indemnitor, that the vendor will indemnify the case if the leak was from the vendor's computers, something that doesn't have to get into hard questions of fault. Even that might not be known at the time the case starts. And the long story short of all this is that it's really difficult to craft a good data breach indemnity clause, and there's a reason vendors are resisting them. So if you are the vendor, I would do everything you can to try and resist that clause. And if you are the customer, understand what's at stake for the vendor and why it's so difficult to get it done. We see a lot of data breach indemnities happen where where there is a data breach from the indemnity from the vendor, but there's some kind of limitation of liability on it. Usually indemnities are excluded from the limit of liability. We're going to talk about that. But in some cases, the indemnity isn't excluded for data breach because there's just no other way the vendor can swallow the risk. So be aware of that. Be aware, too, that you don't need a data breach indemnity for the vendor to be responsible for data breaches. People sometimes sort of forget that an indemnity is kind of an unusual and extraordinary remedy. You're responsible for a data breach if you've breached your obligations. You've got a data security clause, maybe you've got a GDPR data processing addendum. If the breach really is the vendor's fault, it's probably in breach of contract, and you don't need an indemnity to address that. So those are the difficulties around a data breach indemnity. It still gets done a fair amount, but if you're the vendor, I'd say do everything you can to resist it and limit it. And if you're the customer, try and get it, but recognize that there are these challenges. The final thing I just want to make you aware of is something you may have seen, which is sometimes the vendor wants the customer to be an indemnitor. Say a cloud computing vendor is holding all this data for its customer, and shockingly to the customer, some of them, including some of our clients, say, you've got to indemnify us for a breach, even if it was from our computers. The logic of this shocking and potentially offensive demand is the vendor is saying, we're going to take your data, whether it's too risky or not. We're not going to look at your data and vet you and decide whether we want it and we're willing to hold it. You could have 50,000 social security numbers or nuclear secrets or something really scary, and we're going to take it anyway at reasonably low prices, and the price for that is you defend us from data breach indemnities. And as shocking as it sounds, we do have some clients who get that done. The bigger customers will always say no, but sometimes they get done. So be aware that the indemnity can go in the other direction. All right, that's data breach indemnities. And I think we're going to hold questions about that to the end because we're running a little behind. And I want to move on to IP indemnities. So we talked about a minute ago the basics of what an IP indemnity is. So I don't need to go back over that. You know, the vendors defending claims about its technology, patent claims, copyright claims, maybe trade secret claims. I want to talk about a couple of issues that arise in IP indemnities, and then talk about where really the action is in an IP indemnity, and that's the exception. So issues to just think about briefly is does the vendor promise to protect claims about all IP or IP that existed as of the time of the contract? And does a vendor promise all IP or just IP under some jurisdiction's law, like American filed patents, US IP, or European filed patents, etc.? And there's no right answer to this. If you're on the customer side, I think you want to say, look, we're getting your technology. We want to be able to use it, you know, in every way we're authorized to use it. What difference does it make to us if the lawsuit is generated by Indian patent or an American patent or European patent, it's your technology, you should defend it. And that's a good argument. And same argument, what difference does it make to us whether the patent was filed before or after we executed the contract? It's your technology and you defend it. And the vendor's argument is, of course, we don't have the resources. It's not reasonable to ask us to have done patent searches to check the availability of IP rights all across the world. We're operating in the United States, or we're operating in the European Union. And so we can't make that promise. Mostly I want you to be aware there's no right or wrong answer. Each party has good arguments. Push the argument that's better for you. The other thing I want to make you aware of about IP indemnity issues before we dive into the exceptions is the content indemnity. If you're a SaaS vendor, you very well may want to get an IP indemnity from your customer. It's not about your technology, of course. No sane customer is going to indemnify you for claims about your own technology. It's about content that they put up on your system. If your system allows them to upload drawings, photographs, comments, etc., you could get sued for IP infringement for hosting that stuff. Now, there's some limits to your liability under the Digital Millennium Copyright Act. I won't go into that. But anyway, a lot of vendors are getting from their customers a limited indemnity covering content put up by the customer. And it's worth thinking about. If you're a tech vendor, if you're on the customer side, don't be too shocked by it. All right, the real action is on the exceptions. That's why I have the two angry lawyers in silhouette down there on the slide yelling at each other. Because there are 5 typical areas of exceptions that you see in IP indemnity agreements, and understanding them will take you a long way to getting your indemnity done. So the first 3 are usually relatively non-controversial. The indemnity doesn't apply if the claim is triggered by the customer's breach of the contract. The customer goes off and does something with the technology that wasn't authorized, that violates the contract. Most people agree the vendor shouldn't have to defend that claim. Or the software the customer revised the software, the technology, without the vendor's consent. Again, it's not even clear that the typical indemnity language would cover that without the exception. But vendors just like to make it clear that's not our problem. And most people find that pretty fair. 3, the failure to incorporate updates. In some case, like say with a software system, the vendor hands out updates to its software that are intended to get around a patent problem. They're doing the technology a different way. If the customer just refuses to input the update and then gets sued, the indemnity shouldn't apply. And usually that's pretty controversial, pretty non-controversial. 4th exception, this is a little more controversial, but not too bad. The vendor's development based on the customer specs. A lot of these contracts say that the vendor doesn't have to indemnify the customer if there's a claim based on specifications provided by the customer. We built it to your order. Now, smart customers will say no to that, or at least they'll want to limit that. If the customer provides very broad general specifications, build us an HR system with the following, high-level functionality. The general view is you could have programmed that a million different ways. If you chose one of those million ways that infringed IP and we get sued for it, you should defend us. And so what customers, if they're smart, want to throw in language to the extent that the claim is based on the specifications, you don't have to defend us. In other words, if there was only one way to do it, if the specifications were really technical, and anything built on those specifications would create the alleged infringement, trigger the lawsuit, fair enough, the vendor doesn't have to defend. But if there was lots of ways they could do it and they just happened to stumble across one that created a problem, the vendor should defend. And so that to the extent language you often see as sort of a way of moderating that. If you want a sample of that language and all of these exceptions, go again to techcontracts.com. There is under the indemnity tab, you'll see these exceptions under the clauses library. The most controversial of the exceptions is the interface with third-party technology, at least with sophisticated customers. This is where the vendor says the vendor says that we don't have to cover claims based on the interface of our technology with technology we didn't provide you. You could call it a combination claim, a claim that's really about intellectual property rights and the way these two systems fit together. That sounds pretty fair. It's a third-party technology, but the customer's view is this. What if we used your, say, software as a service system with a typical browser? You didn't tell us not to use Microsoft Explorer, and it's the way those two interact that creates the claim. We shouldn't have to defend that claim. That's still about your technology vendor. And so a smart customer will push for language that instead of saying no interface with third-party technology is covered, will say something like, if the system interfaces with third-party technology in a way that achieves functionality described in the system's specifications, functionality that the system was supposed to do, the vendor's covering it. On the other hand, if the customer goes and uses the system with a third-party technology in some unexpected way, trying to do something that the specifications don't describe, that the system doesn't describe, they're kind of going off the reservation on what they use the technology for, then the vendor should be able to get off the hook. That is a compromise for addressing this interface with third-party technology. Now, if you're scribbling furiously to write down that concept, don't worry. Again, if you go to techcontracts.com and the clause library, you'll see examples of that language. So you can just use that language for free for your own concepts. Again, the concept the smart customer wants, and you should go after when you're the customer with your vendors, is if we use the technology in a way that's authorized by its documentation and its specifications, then even if we're using it in combination with a third-party technology, it should be covered. It should be protected by the indemnity. But if we're using it in a way that's not authorized, if we're using it in a way that's not described in the documentation, then fine, the vendor gets off the hook. Now, of course, if you're the vendor, you want to resist this. And very often you can get the typical language because few customers notice this issue. But be aware for the smart customers who will. All right, so that's our IP indemnity exceptions. As I said, most of the action in our negotiations on IP indemnity is on the terms of these exceptions, not on whether to have the indemnity or not. Before we move on to secondary IP issues, Garrett, any questions pending right now?
No.
Okay, great. Okay, so secondary IP issues. I've really just given you a couple issues to think about. This is sort of examples of stuff that people tend to do wrong in technology contracts that relate to IP. And it's two things. It's feedback rights terms and trademark licenses. And I'm going to cover this pretty briefly because they're relatively simple. So a feedback license is language you may have seen where, let's say you're the customer in a relationship with one of your vendors, and it says, if you come up with an idea for improving the vendor's product or the vendor's service, you hereby grant the vendor a license to use it. Or some of them even grant the vendor ownership of it. So just by communicating your idea for making the vendor's product better, you're automatically granting the vendor a license to it. A lot of times these are looked at as kind of non-controversial, and if you're on the receiving end of one of these promises, you're good. No problem. The problem is if you're on the giving end of one of these promises, I would watch out. What you're granting the vendor is incredibly broad, undefined rights to who knows what. Who knows what kind of a concept is going to be incorporated into feedback? What kind of thoughts about your own products and services that are communicated to a vendor as part of some kind of suggestion? What if, something inherent in the idea one of your staff gives your vendor isn't going to find its way into a patent application at some point in the future? Have you granted a license to that patent? And I don't know the answer. It's just the feedback license language that you typically see is just too incredibly broad and vague to say with any certainty what you're giving up. So if you're on the giving end of that promise, you're taking a real risk. It can cast a cloud over your own IP. It's also to some extent overcaution on the vendor's part. It's based on this fear that IP is something, that ideas are something you can own. In fact, you can't own a patent in an idea. There has to be a real invention there. You can't copyright an idea. You can copyright text, you can copyright a paper that describes an idea, but that doesn't keep somebody from reading the paper and taking the idea and running with it. They just can't copy the words. So to some extent, there's a misunderstanding of IP that is driving the vendors to kind of ask too much. Again, if you're the vendor and you're getting these feedback promises, it's fine. But if you're being asked to give one to your vendors, I'd be very hesitant. And there's a good compromise that I can offer you to give your vendor something, but not give this full feedback license. And that is this promise I've got here on the slide. The vendor said that instead of a feedback license, you say the vendor agrees. The vendor does not agree to treat any feedback as confidential, and nothing in this agreement restricts the vendor's right to use, publish, or otherwise exploit feedback. You're not getting into intellectual property because you're recognizing that the chances that an idea feedback will contain any IP are low. You're just confirming that no NDA, no confidentiality obligation is going to tie the hands of the vendor regarding feedback. And that's usually a pretty good compromise and gets the vendor most of the security it wants from the feedback license without totally giving up on the concept and without the customer, giving a license to who knows what. So that's the feedback issue on secondary IP issues. The other one is just a real quick issue on a couple quick things on trademark licenses. So a lot of times technology contracts have a trademark license in them. Say you're distributing or reselling somebody else's technology, and you're going to put their logo on your site, or you're going to put it in your system. There's a trademark license, hopefully explicit and clear in the contract, maybe sort of implied. There's a couple things you need to do in trademark licenses if you're granting that right, if you're letting your partners use your trademarks. One is you want some magic language that says goodwill inures solely to the benefit of the licensor. That means the public perception of quality that attaches to the trademark belongs as an asset to the trademark owner, not to, say, the distributor who's passing technology out with that trademark. That's really important. I don't know if any of you have heard of the Ahwahnee Hotel in Yosemite Park, but it's a hotel that the government, which owns the park, licensed out. They gave the right to run the hotel for decades to this hotel operator, and they let him use the name Ahwahnee, which ultimately is a trademark. And then when they took back the contract and wanted to give it to someone else, they found they had lost the rights in the name Ahwahnee because they didn't have this goodwill inures to the government language, because the reputation for quality built up around the name Ahwahnee belonged to the operator. They didn't have language saying that reputation belongs to the government, so they had to give up on the name Ahwahnee. That's the reason you have this goodwill inures solely to the benefit of the licensor. It's a short sentence. You can, again, find it on techcontracts.com for free. Put it in there. The other thing is, don't grant naked trademark licenses. A naked license is where you grant your partner the right to use your trademarks with no quality terms. You want terms that say something like the vendor will, the distributor will comply with the customer's or the manufacturer's written trademark management policy, something along those lines. That's really important. Because if you don't have any restrictions on somebody you're granting trademark rights to, what you're essentially telling the world is, we don't really care about the quality that goes with this trademark. And the result is you could actually lose the trademark altogether. If the trademark is subject to naked licenses, if it's passed around to whomever, without restrictions, a claim could arise that it no longer qualifies as a trademark because it's not restricted to a certain level of quality or certain type of good, something along those lines. So you want some kind of restriction on the other party's use of the trademark, either the right to review marketing materials or review the quality of products, or maybe some written trademark policies. You don't want to grant a naked license. So those are two brief warnings about trademark licenses. We're running a little bit behind, so if there are any questions, I will take them at the end. So let's talk about our last three topics. Software as a service escrows. This is another real brief one. Very typically you see in this business software as a service escrows, which basically people have taken the concept of the software license escrow, the typical old software escrow where you put source code in escrow, and they've applied it to software as a service. The customer is worried that, say, a software as a service vendor is going to go out of business and leave them in the lurch, and so they want the source code. They want the code in escrow. And it's not just the source code. You need all of the code. You take all of the vendor's software and you put it in some kind of an escrow. My advice to you, if you're on the buying end of one of those escrows from one of your vendors, is don't do it. What I invariably find when I'm in negotiations that involve a software as a service escrow is if I ask the vendor, could we use your software if we got it out of escrow? You get some ridiculously honest engineer in the room who probably shouldn't be there, who probably says, oh, no, you'd never be able to use it. In other words, people are putting SaaS vendors' code in escrow in the hope that if the vendor goes out of business, they can just pick it up and use it, and it's totally impractical. This is different from software that you bought and you've got running in your system, and all you need is the source code so you can sort of look and see how it works and maintain it. If you're getting the software run by a SaaS vendor and you want to use it the way they do, you're going to have to set up a whole technology infrastructure like they have. You're going to have to get an account with with Azure or Amazon Web Services to host it. You're going to have to buy servers. You're going to have to get engineers. I mean, the effort of sort of replacing your SaaS vendor is a whole different thing than the effort of just replacing the maintenance services provided by your on-premise software vendor. And so what you tend to see is people are signing on to software as a service escrows, thinking it gives them some security, and even paying for it when it's of no use whatsoever. So if you're on the buying end, look real carefully and ask hard questions. What would we do with the software if we got it out of escrow? And if you're on the selling end, if you can get them, great. No complaints here, but be aware you're not providing anything that's likely to be of any value. The alternative to a software as a service escrow, just so you know, is what you call step-in rights. Instead of, an escrow agent handing you the software, taking it out of a box and saying, okay, now go build a system and run it, is you have the right to go in and take over management of some of the vendor's computing resources that it's got hosted, say, with its cloud data host. It's Amazon Web Services, somebody like that. You've got the right, instead of trying to build a whole new system to run that software as a service, you've got the right to go in and manage the existing system. That's hard to get. It's a contract you do see done sometimes. You got to involve a third party, the web host, and whatever other companies are providing the technology to support it have to agree that you can step into the vendor's shoes and run their technology. It's a whole other course we could do on how to make a step-in right work. But be aware that that's an alternative to the usually pretty useless software as a service escrow. All right, so that's escrows. Topic 6, limitation of liability. I want to talk in particular about this because we're in a world of insurance, and you're all here because your insurance carriers are eager for you to learn. Want to talk just a little bit about the fundamental concept that limits your liability. So it's typical that every technology contract just about has this language, and if you're getting pushback from your customers saying it shouldn't be there, you should be able to say, no, it's got to be there. And the typical language is that there's some dollar cap on liability, that even if the vendor's at fault, its liability will not exceed X dollars. And it's usually the vendor that's protected. We'll talk about protecting the customer. It's also typical that there's an exclusion of consequential damages, which means the sort of large unpredictable damages that are specific to any particular type of loss, as opposed to the more predictable ones. My main message to you on this slide is just to be aware of the metrics that go into determining the numbers. people ask me, what should the dollar cap be? Should it be the contract price? Should it be 3 times the contract price? Should it be some fraction of the contract price? And the answer is there isn't an answer. The thing for you to be aware of is that this figure is utterly arbitrary. There's no logic to it. So arguments that you might get into about what's fair are mostly silly. There is no requirement. There is no logic to it. It's arbitrary. I can tell you what's typical, and what we see in most of our deals is the limitation of liability is pegged at somewhere around the price of the contract. A vendor favorable number would be that it's the price of each statement of work or order under the contract. The price of the statement of work or the order in question. Whereas the customer wants a bigger number and say, the price of the whole contract. Big customers with a lot of clout will ask for something like 3 times the price of the contract, something like that. And there's the debate. As I said, don't get into silly battles about what's fair. Recognize that you're in just kind of a zero-sum debate, and maybe use it as a bargaining chip for something else, trade it off, try and get the number that's most favorable to you. The warning I have for you, though, is don't make the number so low that it's unconscionable. Unconscionability is a concept in the law of just saying a contract is so unfair to one party that the courts won't enforce it, even if both parties were grown-ups and should have known better. And unfortunately, I can't tell you what is a number that's so low as to be unconscionable. But if you feel like you've gotten your limit of liability down to a number that is so low that you really just don't have any risk in the contract, that there's no meaningful consequences if you breach and if you don't serve your customer well, you've probably gone too far. It's probably unconscionable. Something that's typical in the industry, like 1x the statement of work or 1x the whole contract, is very unlikely to be unconscionable because it's so typically done. Something that feels unusually low, you want to start to worry about that issue. So that's the unconscionability concern. It's sort of a restriction on your right to do a good job negotiating. You don't want to do too good a job. Exceptions to the limitation of liability are really important too, and sometimes people forget about these issues. So first of all, if you're a tech vendor, you may be seeing customers that are asking you to exclude gross negligence and intentional wrongdoing from your limit of liability. I think it's pretty effortless to exclude intentional wrongdoing, saying if you intentionally injure the customer, your liability is not protected by a limit of liability. Because the law is going to do that anyway. Most states' law will blow through any attempt to protect yourself against intentional wrongdoing and saying, sorry, you lose. You can't do that in the contract. I'd be more hesitant to accept gross negligence as an exception. Gross negligence is just bad negligence. The problem is that the point of a limitation of liability clause is to keep you out of court. And if you say, any liability for wrongdoing that's not intentional, you're probably not going to get sued that often. The number is going to be clear. But if you make gross negligence the exception, you create an enormous incentive. Every claim against you is going to claim gross negligence. And you get dragged into court. Now, you're better off with gross negligence, you're better off with some limit of liability, even if it doesn't cover gross negligence. But if you can resist that, I'd say do. Obviously, on the customer side, if you can get gross negligence as an indemnity, as an exception to the limit of liability, it's a good idea. But be aware as a vendor, you're losing some of the benefit, which is to make most claims not worth suing over. Or a better way to put it, most claims easily settlable because you have a clear number. The other kind of exceptions that are typical is for indemnity. It doesn't make a lot of sense to limit liability on an indemnity. You're basically saying one party is going to defend this claim. We agree that this type of claim is really one party's problem, like an IP claim. And then you say, oh, but it's no longer our problem after we've spent $500,000. Most people agree that doesn't make a lot of sense, and the indemnity is not subject to a limitation of liability. As I mentioned before, nevertheless, making a data breach indemnity subject to it is not so unusual as a compromise, but it doesn't fit very well with the logic. And then NDA breach of confidentiality, you usually have terms that say at least the exclusion of consequential damages doesn't apply to NDA breaches. And without getting into the technicalities of it, basically the loss for a confidentiality breach is usually consequential damages. So if there's no consequential damages allowed, then you have no rights. And that's why you usually see NDA breaches excluded from the whole limit of liability or just from the exclusion of consequential damages. And I apologize, it would be, consequential damages is a complex concept. I'd love to explain it in more detail. It is explained in the Tech Contracts Handbook, but we don't have time to spend on it now, nor do you need to. Just be aware that that's a typical exception. And then final thing I want to say about limits of liability is if you make the limit of liability mutual, there's some additional exceptions you should add. In other words, if you're the vendor and you also limit your customer's liability, you want to make sure that their liability is unlimited for certain things. Of course, the indemnity. You also want to say IP infringement. You don't want to say their liability is limited to, say, the contract price. What if they then, if they have copies of your software and instead of making 2 copies, they make 80,000? You don't want the contract price to limit their liability. So you want to say IP infringement is not covered by the limit of liability. Otherwise, it's kind of a free license. You also want to say their obligation to pay fees is not restricted, is not in the calculation of the clause. And the logic there is if the liability limit is, say, the contract price, and they don't pay the contract price and they breach in several other ways, you don't want your only claim to be limited by the contract price, because then all you can get out of them is the money they were supposed to pay anyway, and you can't get any damages for your losses. So you want to say, and again, there's free language on this for this at the site, you want to say that IP infringement, the obligation to pay fees, and indemnity are not covered by the customer's limit of liability where you make it mutual. All right. Our final 7 points, and then we're going to take some questions. Our final, I think 5 quick points, and then we're going to take questions. And these are 5 common errors and risks I'm going to spend less time on. One is unilateral amendment. If you've got terms on the web that basically say, we can amend this contract at any time, and you can go to those terms, and you customer have to review this page periodically, and if you keep using the system after we amend the terms, the amendment is effective against you. Be aware that that might not be enforceable. In many states, a lot of questions have been drawn about that. That very well might not be enforceable. You want some kind of system that says, essentially, we got to give you notice of the revised terms, and you may even want to say, if you refuse the amendment, the new terms don't go into effect until the next time you renew. Something along those lines, so that you're not making an unrealistic demand on customers to do things like review terms. And again, there's free language at techcontracts.com with an amendment clause that works much better. Instead of just saying we have the unilateral right to amend terms, which is, it depends on your state. It's very risky that your amendment clause will be totally ineffective. So be aware of that. Second warning, some people want indemnities for everything. They want a clause that says, if anything bad happens, the vendor's going to indemnify us. My main lesson to you is this. Indemnities are not meant to protect anybody against anything bad happening. You are not insurance providers, except those of you who are insurance providers, but we're talking to your clients, the tech vendors. Resist the concept that there should be an indemnity, an obligation to defend lawsuits for anything bad that happens. The point of an indemnity is that one party creates an unusual risk to the other, like an IP risk, and you want to cover that. Always look at an indemnity as sort of specific, narrow exceptions. And if the other party is asking for really broad indemnities for everything, remind them that if you breach, you're liable, even without an indemnity. You don't need an indemnity for everything to be responsible for your own wrongdoing. Third point, if you're the contract drafter, as painful as it may be, pay attention to things like technical specifications. If you're customizing technology for a third party, for instance, I think the contract drafter should be responsible for reading those specifications and editing them to make them clear. It's arguably the most important part of the contract. You want to say, well, I'm not a technologist, it's not my responsibility. But most likely, as the key drafter or negotiator, your responsibility is to make sure the contract is clear. And I got news for you. There's actually no such thing as technicalese, any more than there is legalese. If they're written in English or whatever language the contract's in, you can understand technical specs. You just got to go back and ask questions. If you can get the specs to a point in a customized contract where you can understand what they mean, then they're probably clear enough. If it's just, the engineers say, well, everybody knows what it means, very likely that's not right. If you can't understand it, it's probably not clear enough. Point 4, it's kind of fading away, but there's still some people who throw non-disclosure agreements, confidentiality agreements at data security. Say, we'll sign an NDA for your data. It doesn't work. Data security is about encryption and GDPR and all the stuff we talked about. NDAs are about protecting trade secrets. They're much more limited. So don't slap an NDA on data security. Use a real data security clause. And then finally, don't mess with non-compete clauses without an attorney's help. A non-compete clause is where, say, tech vendor and its customer agree that they won't go after each other's business if their businesses overlap. We're going to provide you with these services, but you promise not to use what you learn from us to go and poach our other customers. You promise that you're not going to go into the XYZ market in the Northwest region, and we won't do it in the Southwest region. Any clause like that is playing with fire because of antitrust law and unfair competition law. And the best advice I can give you is don't just sign them. It's too complicated to explain, what's okay and what's not. You got to have legal help. You got to talk to an antitrust unfair competition lawyer about any clause that restricts any party's ability to compete. Just don't mess with it without really experienced help to address it. All right, well, that's the last of our bullet points. I think we have about 6 minutes or so to take any questions, if there are any. Do we have any, Garrett?
Yes. Question about indemnification. Should the indemnification amount be limited by the insurance coverage in place?
Yeah, that's a really good question. There's no logic in the contract that says the indemnification amount needs to be limited in any way. But there's also no reason you can't do that. So let's say we're talking back to our example of a data protection indemnity where just by accepting the indemnity, the vendor is taking some unusual risks. I think for the vendor to say to the customer, we're very hesitant to do this in the first place. This is the extent to which we have coverage, and that's going to limit us. There's a logic to that within the contract. That said, before doing that even once, I would talk to your insurance vendor or your insurance broker and see how they feel about it. Insurance companies are generally hesitant to have you set up a contract system that makes them liable and you risk-free. Is this going to impact your rates? Is this some kind of violation of your policy? You want to check on that. But in general, there's no restriction in a contract for limiting the extent of your liability under an indemnification clause, which again is an extraordinary clause. So it's worth trying it. If you're on the customer, though, and a customer end, just to look at the other side's view of this, and you get this kind of request, I think you have a legitimate answer, which is, look, we've agreed that you're covering this type of suit. We want you to cover it. It's not our problem the extent to which you have an insurance policy. We've agreed that, say, IP claims about your technology are your responsibility. Why should it suddenly become our responsibility when your insurance vendor is, finished providing you with your benefits? We agree that this is your problem and it makes sense. We don't want to defend your technology. So you might get a powerful argument on the other side to any limit on an indemnity obligation, and there may be some good logic to that.
Okay, I think that's gonna do it for today. I'll give David another plug. If you want to connect with him outside of the webinar today, his email is david@techcontracts.com. Certainly visit the website. It's a tremendous resource, and there have been a lot of questions about getting a copy of the materials and the webinar itself. We will be releasing the slides and the recording of the webinar later today, if not tomorrow. I'd like to thank David for joining us. It's always a pleasure having you, and I'd like to thank everyone for attending today's webinar. If you'd like to receive additional content, please make sure to talk to your TechAssure agent or broker and make sure they keep you posted on future events. With that, I will conclude today's webinar. Thank you for joining.